The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation-building series, The Law and You. This is program number 903, and it is coming to you on Monday, the 18th of June, 2018. On this program, I will speak to you on the topic Private Agreements for the Sale of Real Property. But before getting into the topic, a few preliminary comments. Firstly, and as usual, my condolences go out to all families which have suffered recent bereavements, and in particular, the Rose family. I was shocked when I heard of the murder of Tony Rose, the daughter of Granny Rose, who was recently buried, and the sister of Conley Rose, Renwick Rose, Dexter Rose, and others. Now, not only was I shocked because I knew Tony quite well. In fact, she is the cousin of my wife, Juliet. But she was extremely well known to me before she migrated. And the circumstances of that murder was simply awful. Simply awful. And to think of the Rose family, they've just buried Granny Rose, beloved of all. And this daughter of Granny Rose apparently came home for the funeral of her mom. And pending her return to the United States of America, her life was wantonly snuffed out by a murderer. Ironically, just on Friday, in his usual newspaper column, Renwick spoke about the changing mores in society, changing values. A theme which Dr. Adrian Fraser in his column also wrote about. And I want to join the brigade of those raising the alarm that this society is in danger of going downhill in so many areas of social life. My deepest condolences to all the members of the Rose family and all the friends of Tony Rose. And we also heard on the weekend of the apparent suicide of the female student attending secondary school in Mesopotamia, a girl of tender age who the reports claim hanged herself. My condolences go out to her family, as well as the families of those who were recently drowned, especially the family of their brother whose body has not yet been found. We have to keep praying for this country. On the same note of death, let me remind all spiritual Baptists and other persons who are beloved of Patriarch Edmund John that the funeral of the late Patriarch is to be held this coming Sunday, the 24th of June, at St. Elizabeth Cathedral, Belmont. The body will be lying in the church from 9 in the morning for viewing. But if during the week persons would like to do some viewing at the funeral home, they can always go to the Ever-Ready Funeral Home at French's, popularly known as Mills, and they would be able to view the body there during this week. But the official viewing on Sunday morning begins at 9 o'clock, and the funeral service will start sharp, promptly at 12 noon. It will be a long service, and we are fortunate that it would be hopefully carried live on television and certainly carried live on nice radio. We're hoping to be able to conclude the television arrangements in the course of the week, but the only problem is a technical one. If that is overcome, then the funeral will be seen on television. Of course, because of the way where the church is situated at Belmont, traffic is going to be a problem. Because with the diversion of the road to Mespo a couple of years ago, traffic to Mespo passing on the Belmont side, that traffic passes right beneath the church, underneath the church, and our church is situated up on a hillside above the Seventh-day Adventist Church. Traffic police have been asked to be there, and they will be doing their best, and I want to ask all motorists who would be either coming to the funeral or passing through that part of the road on Sunday to bear with everybody, because things would be slow. And let me thank the Seventh-day Adventist authorities for giving permission for some parking to be done in the yard of their church, which, as I said before, is just below St. Elizabeth Cathedral at Belmont. Thank you in particular to Pastor Dermot Batiste for the very kind indulgence and cooperation. Thanking the Commissioner of Police for the favors we ask him for in relation to the funeral. And in advance, we thank all concerned who would be assisting with the arrangements. But those coming to the funeral, be prepared for some delay. So try and get there early. Now, I had neglected last program to send Happy Father's Day greeting to all fathers in advance. So, belatedly, I hope all of us fathers in the state had an enjoyable Father's Day. And for those few fathers who might be in a state of mourning, we join with you in solidarity. Just remains to me finally to congratulate all of the children who have passed their CPEA exams, especially those who have distinguished themselves. My congratulations to all of you. All right, let's get into the topic now. Private agreements for the sale of real property. Real property, let me begin by explaining what is meant by real property. Although, for those of you who have been following the law and you these last 20 years or even just a few years, you would know by now that real property refers to land and house and land. The opposite of that is personal property, which is anything that is not land or house and land. With one little rider. In law, chattel houses, that is, board houses which are resting on land on posts, or even if they're resting on a removable concrete foundation, are regarded as personality. Board houses that are removable are not regarded as real property because they do not form part of the land. But wall houses, trees and crops growing on land are part of real property, real estate. This is why you hear about real estate dealers. Those are people who deal in the sale of property, land and house and land. So throughout the program, I would interchangeably use the terms property or land or real property, all mean the same thing. And the categorization I have mentioned is to be distinguished from the sale of personal property. So if you are selling a vehicle to somebody, what I'm saying on this program does not apply to you. If you are selling any livestock, if you are selling agricultural produce, or any produce of that, for that matter, if you're selling a gold chain, these things don't apply. These only, what I'm saying to you on this program would only apply to land and house and land. All right? So, in the topic, you will see the term private. And that is what I want to emphasize on this program. Where arrangements are made with the help of a lawyer, then I'm not calling, those are not what I mean by private arrangements. I mean by private arrangements and agreements, I mean those which are taking place between individuals without legal assistance as a form of self-help. Now, there is absolutely nothing wrong with two persons who are not lawyers entering into an agreement to buy or sell property. Nothing, the law doesn't say they can't do it. But you have to understand that if you are planning to enter into an agreement with somebody else to sell the person a piece of property, and you don't plan to use a lawyer, and the person to whom you plan to sell the property does not plan to use a lawyer also, both of you are running serious risks. Because the transfer of property, the placing of encumbrances on property are matters which are regulated by the law. So if you have a deal to go through with somebody involving selling land, for heaven's sake, go and see a lawyer. Or each of you can go and see your own lawyer and let the two lawyers collaborate. But to attempt to do it without a lawyer, or without two lawyers, each representing one side and the other, is potentially troublesome because it could end up costing you much more than you think you will save. I know some people say, well, they have money to waste on lawyers. Okay. Or let us try and save legal fees by doing it ourselves. Nothing wrong with that if you know what you are doing. In the first place, you see, when you see a piece of land somewhere and you are entering into negotiations to purchase the land from the alleged owner, how do you know that the person who is planning to sell you the land has the authority to sell you the land? Just over the weekend, listening to the news from Jamaica, which I do almost every day because I go on to YouTube and I try to get news from Jamaica, Barbados, Trinidad, Guyana, and a few other Caribbean places. It is so easy these days. You just have to use your computer. Listening to the news from Jamaica over the weekend, I heard a report that a fellow has been indicted for arranging to sell the same property in Jamaica to different people, collected money from all of them, and it turned out that the property was not even his. But he would go take them to view the premises, the house and the property, and take money as a down payment. And next thing you know, the property does not belong to him. So the first thing you are required to ascertain when you are dealing with somebody over the purchase of a parcel of land or property is to ascertain whether the person you are speaking to has the legal authority to negotiate a deal with you. Now, the property hasn't got to be his or hers. But if they are dealing with you, you need to know they have legal authority from the real owner of the property. Property could belong to somebody who is abroad and who has authorized somebody to sell the property for them. Nothing wrong with that. But you have to, first of all, make sure the person has the general authority. So, if you are discussing a property with somebody and you want to buy it and they say they want to sell it, and you're doing it privately, you need to find out if the person has the authority to deal with you. And suppose they tell you, oh yes, it belongs to my cousin and he called me the other day and told me to sell it for him. Well, you can't have deals with real property with word of mouth arrangement. The law does not recognize merely oral transaction, that is word of mouth transactions, dealing with real property. Therefore, you have to make sure the person has proper authority. But suppose a person says, the land is mine and I want to sell it. How do you know that it is not family land? How do you know the person doesn't jointly own the land? How do you know that the person even has an interest in the land which he is capable of selling? These are things which a lawyer will find out for you because that is what the lawyer is trained for. The lawyer is trained to investigate title to property or alleged title to property and to advise accordingly. So the lawyer would know that he or she should check out cases of alleged authority from the owner, or if the person claims ownership of the property or the land that he wants to sell, the law would know how to go about checking that at the records at the courthouse. Excuse me. Now, you may have a piece of land for which you have a title deed. Fine. But somebody else may have acquired a right to the land by virtue of what is called adverse possession. That is, somebody may have actually occupied that property as owner for more than 12 years, even though you have your title deed in a trunk at home. Suppose you buy a piece of land or property and you go away. You got your deed, feel nice, you put it up, or you give somebody to hold for you, and off you go. You go on to England or America or Canada or elsewhere. And for more than 12 years, you are away from St. Vincent and Grenadines. You don't have anybody you have authorized to occupy the property on your behalf, but some stranger goes and occupies that property behind your back while you are away. After 12 years of occupying your property as the owner, without having any permission from you to be there, they can go and apply to the court for a possessory title to your property. Even though you have a title deed for it, because the law of St. Vincent and the Grenadines follows the law of England and the law in many other, in all common law countries, which says that if somebody is adversely occupying your property for over a certain period of time without you having taken steps to get them off through court process, and they don't have your permission to be on your land, they have simply taken it as a squatter, and that time passes, the law regards your right to the land as being extinguished, even though you have a piece of paper saying the land is yours. That is what adverse possession is. And we have a law here called the Possessory Titles Act, which sets out a procedure by which persons who have been squatting on another person's land for more than 12 years, in certain circumstances, can go and apply to the court and say, look, I want a title deed for this piece of land because I have been occupying it as an adverse possessor. Now, let me say this before I go any further. There are circumstances attached to the ability to claim possessory title. So it isn't every case in which somebody has been on land for 12 years you can go and claim it. A lawyer will advise you when you tell the lawyer the facts. A lawyer will advise you whether you have a good claim. So I'm not saying that in every case 12 years or more possession of property gives you the right to go and apply to get a title deed. It all depends on your fulfilling certain conditions. So check out a lawyer. Don't go and say, oh, I've been on this land for more than 12 years, and Mr. Campbell say, if you're on land for more than 12 years, it's yours. No, it all depends on a lot of things. And when you go to a lawyer to get advice, the lawyer will ask you a series of questions. If you answer them truthfully, and not everybody answers lawyer questions truthfully, but if you answer them truthfully, the lawyer would then be able to advise you, yes, you have a good case, let me draft a claim for you. Let us fill out the form and put the advertisement in the newspaper and so on. Or the lawyer will say, well, look, sorry, in those circumstances, you can't claim because, for example, it is family property and other members of the family have the same interests as you, and adverse possession does not apply to certain cases of family property. All right? So tell the lawyer the truth. And remember, I had 2 programs in the past called Tell Your Lawyer the Truth. That is exactly how the programs were titled. Because I've been at the bar now for 38 years. And in that time, I have had more than a fair share of people coming to me with a lot of lies. And you will act on their behalf. And if, for example, the matter goes to court, it's then in court when the case is heard, you realize your client has been lying to you from top to bottom, from morning to evening. Most clients tell the truth, but some clients, Lord help them. Easy. So to get back to the question of making a private arrangement, agreement. If you are going to have money pass as a down payment on the purchase of real property, under no circumstances should you have that money pass without getting legal advice. Otherwise, the person who is paying the money is running a big risk. And I've known cases where people let go thousands of dollars in somebody's hand as a down payment on property, and it turns out that the person can't sign a deed for them because the land doesn't really belong to the person alone. And if land belongs to two or more persons, each of them has to sign a deed for you. One person cannot sign and sell land that belongs to him and other people. So if you're going to let go money as a down payment in somebody's hand, you are doing it at a risk if you don't go through a lawyer. And you could end up losing all that money. Most agreements for the sale of real property are registered at the courthouse, so that if I arrange to sell you property and you come and you bring a down payment to me, and we have a properly drawn up agreement by a lawyer signed by both of us, you can take that agreement to the courthouse, have it registered, where it becomes notice to everybody that you now have an interest in the property because you have paid a down payment on it, on the condition that after such and such a length of time, you pay the rest and you get your title deed. So once that is registered, nobody else can go and say they want to buy the same piece of land from me, because I've already signed to say I've collected a down payment from you. I've already taken your money. And the agreement is at the courthouse registered, where everybody should go and have a look who want to buy the land. You see, once it is registered, the law regards that as what is called notice to the whole world, which means that because it's a registered document, the general public has a right to go and inspect it. They pay an inspection fee, a search fee. The general public can go and ask for a photocopy of it, a certified copy. So a registered document is a public document open to the public. And once an agreement is made to sell the land and it's registered at the courthouse, then that blocks anybody else from dealing with the land. Unless you forfeit the arrangement, you can't come up with the rest of the money and so on, and you say, well, look, you can't go through with the sale. The agreement you sign may well have a clause that if you are not able to complete the sale in such and such a length of time, you forfeit the deposit. Some may have a clause that you return, you get back part of the deposit, but it all depends. Generally, when you make a deposit on the payment of land as a down payment, and you default in carrying through the deal, you would generally lose the deposit. I say generally because there are cases which you may not lose the deposit depending on how the agreement is worded. So as I close off, it's a general caution I'm issuing I'm issuing a caution to anybody who is thinking of doing their own thing when it comes to the sale of land or property. Use a lawyer. Yes, the lawyer will charge fees. That is what he is in the profession for. But you are paying fees to safeguard your interest, to make sure that if things go wrong, you are protected. So if you want to skimp and say, well, you don't want to spend money on lawyers, power to you. But if you find yourself in pocketery, as the common parlance goes, that is really a corruption of the word purgatory, which has nothing to do with legal matters, but it's a slang. We've all been sanctioned, Pocketery, you get in pocketery if you go and do transactions that you go outside the lawyer and you get your foot tied up. So use a lawyer, get legal advice, and do what you're doing in the proper way. All right? Okay. So that is all from this program of The Law. And let me remind you, Patriarch John's funeral, Sunday, 24th of June. The funeral service begins at 12. Viewing starts at 9 to 12, then the service at 12. Go on till 5:30 or thereabouts. Okay? So until next program, I look forward to being of further service to you for another presentation in this public service nation building series, The Law and You. Do have a pleasant week, ladies and gentlemen, brothers and sisters, boys and girls. And may the good Lord continue to bless us all.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.